Good afternoon. Welcome to this Altamimi webinar. We're looking at the new DIFC data protection law. We've got a lot of attendees, as you would expect with the new law. We've got a few people kind of joining at the moment, but we're going to get started because we've got a lot to cover. We've got, as I say, we've got a lot of attendees coming with different levels of knowledge in relation to data protection generally, and the DIFC data protection law specifically. As a result of that, what we're going to be doing is very much a balanced review into the new law. There's a lot of detail in the new law, as you would expect. It's been 13 years since the last one and came out in 2007, albeit we've had amendments and regulations and things to the old 2007 law, but there's a lot of new detail in the law, and it's really good to get into that detail because it really helps in terms of interpreting the new law and for businesses really understanding what their obligations are. We're going to move through it very quickly. Quick introduction from me. My name's Martin Hayward. I'm the Head of Technology, Media and Telecoms at Altamimi, and I'm joined by Krishna Jala, a Senior Associate in the TMT team. And what we're going to do, we're going to spend about an hour on looking at the key issues in the new law. We're going to go into detail on them. We're going to look at really what the new drafting says, look at the words, and aim after as well is to offer an opportunity. You'll see as part of the webinar functionality that you can ask questions, and we very much encourage you to do so. And we want to leave some time at the end to make sure that we can pick some of those questions and answers. And ones we can't get to on the webinar itself, we will certainly get to offline with you. So as I say, let's get started. So let's look at the new law. So it's been a long-awaited law. It's been under development for some time. The pandemic somewhat got in the way, but it's great to see it out. It was released back in June. Comes into force on the 1st of July and repeals the old 2007 DIFC data protection law as amended. And whilst the new law comes into force on the 1st of July, there's a 3-month transition period, 4 months if you go back to the June date when it was released. But there's a 3-month transition period from when it comes into force, and businesses have until the 1st of October 2020 to comply with the new law. And it's been interesting because we've already had queries in from businesses looking at that 3-month transition period. It's a relatively short period of time when you look at other data protection laws that have come in, and particularly one like this where there's a lot of new things to deal with, a lot of new things to understand, a lot of things to put in place. I mean, certainly from a DIFC position, I mean, the DIFC Data Protection Commissioner has always really focused on developing awareness and best practice in the law. So whilst businesses should be focusing on that 1st of October 2020 compliance date and really working towards that to get their businesses compliant with the new law, I mean, it'd be interesting to see how the implementation rolls out. We're going to have regulations to come. We haven't had the new regulations issued yet. We're already getting some guidance though. We're getting guidance on an area such as consent, on the fines and penalties regime, and also around new concepts like high-risk processing activities. And we've been looking at that guidance, and we'll be feeding some of that back to you as part of the webinar. One of the last point on that slide, it's an important one, and it's one we do flag because whilst we have a DIFC data protection law, we also have UAE criminal laws which apply in the DIFC, and they have privacy, data protection elements to them, and that includes the penal code and the cyber crimes law. And spend a lot of time advising clients in relation to the privacy aspects of UAE criminal laws. And it's important to keep in mind that those laws are still in place and they're still applying to how personal data is managed in the UAE. So what have we got as part of the new law? Well, we've got an improved data protection regime, and there's a real focus on transparency and cross-border security safeguards, new obligations, both for controllers and processors, and we're going to talk to all of that. But one real key focus is And it's set out right at the start of the law in the purpose. It's really the focus on data subject rights. And that doesn't come as any surprise to us. Certainly anybody who's dealt with the European General Data Protection Regulation, the GDPR. And there's really that focus on protecting the fundamental rights of the data subject. And as we say in the second bullet point there, that really demonstrates how the new law, the new DIFC data protection law, very much aligns itself closer with GDPR. And we expected this, and this was the approach that's been taken. Interestingly, though, it does diverge from the GDPR in certain aspects, and particularly in relation to the emerging technologies point. And really, we see in the new law some really interesting approaches to applying data protection principles to key emerging technologies, the artificial intelligence, blockchain technology. And we're going to talk a lot about that as we work through the webinar, because it's interesting to see how the DIFC Data Protection Commissioner is looking to balance data protection rights, data subject rights, with the move to emerging technologies. And as we've seen over the last few months with the current pandemic, really that digital transformation is accelerating. It's accelerating before the pandemic. It's certainly accelerated during the pandemic. And we're seeing lots of adoption of new technologies. And the new law is set up, it's future-proofed to really work with those new technologies. And as we know, technological innovation really outstrips laws and regulations. There's no way of stopping that. But one thing we'll really see in the new law is the way in which the DIFC Data Protection Commissioner is trying to balance that. And the last point there is an interesting one, because it very much looks at how the new law is going to help take DIFC one step closer to achieving what's known as adequacy status, so basic under the GDPR. And really what this means is allowing the movement of the much more freer movement of data from the European Union to the DIFC. And that's going to be, from a business landscape point of view, a real benefit that the new law will drive. So a number of new definitions. Let's start with some definitions. We're lawyers, so we like to start with our definitions. And anything you see in the slides that's capitalized, there's a definition to that in the new law. It's a number of new definitions and revised definitions. We'll look at the revised ones first. I mean, the processing definition's a really interesting one, because that's a much more well-developed, more granular, more detailed definition of processing. And certainly being somebody who's been in the Middle East since 2009, has been advising on the DIFC data protection law since I came to the Middle East. Certainly one of the big areas that we used to focus on and with client advice was really looking at what fell under the processing definition. So it's really great to have a much more detailed definition of what processing covers, but also what it doesn't cover. And then the concept of sensitive personal data, it's been replaced by the new definition of special categories of personal data. And all of the same definitions that we see within the sensitive personal data definition, covering racial and ethnic origin, political affiliations, religion, health and sex life, it's all there in the special categories, but they've added genetic data and biometric data as well. And that's a really useful addition, because as we see much within that emerging technology space, the greater use of genetic data, biometric data, facial recognition, it's great to have that covered in the definition, because one of the things we often used to get asked was, is this type of data, is it personal data? And if so, what kind of category of personal data is it? So there are some new definitions as well, some of which we certainly know, coming from a GDPR background, but these are new concepts coming into the DIFC law. And the first one of that is binding corporate rules. And that's very much a concept that we know from GDPR, really allowing, within a group, personal data protection policy and procedures aggregated, incorporated. It's interesting to see how binding corporate rules is used in the new law, and we'll flag that as we go through. We've got a definition of personal data breach, which we didn't have before. We've got a new definition of profiling, which really goes into the automated processing concepts in the new law. And the new law really reflects the move to automated processing, the application of new technologies to automated decision making, and it's a real focus on the new law to ensure that there's a framework to protect data subject rights in relation to profiling. Got a definition of third country, and that very much calls out the fact that from a DIFC perspective, a third country can be both the UAE and it can be a country outside of the UAE as well. And we've also flagged DPO there because one of the really key new concepts that's been introduced into the new law is the concept of the data protection officer. We're going to talk a lot about the concept of a DPO. Because it's really key for DIFC businesses really understanding their obligations under the new law, and one of those key obligations is whether or not they need to appoint a DPO. So let's dig into the real detail in the law. So who does the new law apply to? As I say, one of the key changes that we've seen in the new law is that it applies to both controllers and processors. Previously, under the old law, the 2007 law, it was really a controller law. Now we've seen it broadened, once again, very much within a GDPR context, and we're seeing both controllers and processors having obligations under law. We're going to talk a lot more later. Krishna's going to talk to the concept of processors' obligations. But for the purposes of just who the law applies to controllers and processors incorporated in the DIFC. So that's they've established, they've set up in the DIFC, and that's regardless of whether processing takes place in the DIFC. So if you're a controller or processor that's part of a group, maybe you've got an onshore branch, maybe you've got a branch or a company in another free zone. If you're in the DI and that onshore or other free zone company is doing your processing, if you're incorporated in the DIFC, though, it doesn't matter where that processing takes place. DIFC law is going to take effect. And also we see it's going to capture controllers and processors regardless of their place of incorporation. If those controllers or processors are processing personal data within the DIFC, and the law is very clear in terms of that needs to be within a stable arrangement, and really what we mean by that is something that's consistent, that's regular, that's frequent, it's not occasional. And that can also include managing transfers of personal data in and out of the DIFC. And we're already seeing queries coming in, particularly from technology service providers who are providing, for example, outsourced services into the DIFC, whether they're running outsourced data center services, whatever, and they're looking now at whether the new law applies to them where maybe it didn't previously. And the law is useful because it really sets out what we mean by processing in the DIFC. And what we mean by that is processing occurs in the DIFC when the means or personnel used to conduct the processing activity are physically located in the DIFC. Now, that's a useful piece of detail for interpretation. It's particularly useful, though, in terms of, and one of the questions I think that will come up there will be really, well, okay, so how does that work for remote services? And particularly at the moment, as we're in a pandemic situation and we're managing remotely, and services are very much being provided on a remote basis, really what that means in terms of from a processing point of view, particularly as remote services may well continue long into the future. So we're going on now to the key data processing principles. And what we've got in the left-hand column is just a quick summary, quick reminder of what those kind of general data processing principles were under the old law. And in the right-hand column, we've got some of the new additions. These are both additional principles. There's some changes and additions to existing principles. And one of the key ones, under the old law, we talked about processing fairly, lawfully, and securely. Added to that under the new law is this transparent concept, and it really goes to the point that processing moving forward under the new law is going to need to be transparent. It's going to need to be documented and communicated to data subjects, and that's really something that businesses need to be grasping now, because there's an administrative requirement to that. There's a lot that needs to be thought through in terms of how that principle of transparency can be met by businesses who fall under the new law. In addition to the new law, there's the principle of processing personal data in accordance with the application of data subject rights. Now, this was it's not really an additional principle. It was in the old law, but it's really been called out now. And as we said at the start of the presentation, it's very much a concept that is very much at the heart of the new law. In addition to that, very much calling out as well the need for personal data to be kept secure using appropriate technical and organizational measures. And there'll be a lot in the new law regarding that principle. And in addition to that, under the old law, there was the requirement that processing be accurate. The data that was processed, I should say, would be accurate and kept up to date. And the new law's added to that and is talking about, you know, that can include erasure and rectification, these kind of data subject rights that Krishna is going to talk more about later, and the requirement to make sure that accuracy, data accuracy and is kept up to date. That can be through erasure or rectification, and it occurs without a due delay. And interestingly, controllers and processors are responsible under the law. It's in the new law to demonstrate their compliance to the commissioner on these data processing principles. So we're going to jump onto the lawful basis of processing. This is getting into the real core of the new law. Is Article 10. There's a number of lawful bases on which you can process. Top of the list is consent. A number of these, consent included, they're not new. It's interesting to look how the drafting, how the language has changed. I mean, interestingly, for consent, we're now talking about consent for specific purposes. We're going to talk a little bit more, well, a lot more about consent in a later set of slides. But it's really important to understand, because this concept of specific purpose is really calling out what consent is being given for is really fundamental to the new law. And then we see some of the previous lawful bases. They haven't changed, necessary for performance of a contract, compliance with applicable law. Some of the language has changed, but it's really the same principles. We've got a new lawful basis to protect the vital interest of a data subject or other natural persons, and it'll be interesting to see how we define vital. Necessary for the performance of a task carried out by a DIFC body, exercise direct or indirect of DIFC body's powers or functions. Those were there before. Also legitimate interest. That's a concept that was in the old law. We'll touch on that. It's a limited concept. It very much isn't the catch-all that maybe people felt it was before as a lawful basis for processing. And it's interesting the extent that it's a legitimate interest, except where such interests are overridden by the interests or rights of the data subject. Under the old law, the language used to be very much about the compelling interests. And we've seen, as say, with the greater focus on data subject rights, we're seeing a balancing out of legitimate interest as a lawful basis for processing. So one of the key areas for processing data is of course, sensitive personal data, special categories of personal data, as it's now called. And used to be that you would apply to the commissioner for permission to process special categories of personal data. That's been removed. And we've got a big new section, Article 11, lots of new detail in terms of how special categories of personal data may be processed. There needs to be a specific legal basis for processing under the new law. And as we've identified there, it needs to come with explicit consent. And the guidance that the DIFC Data Protection Commission has released on consent is really useful for interpreting what explicit consent actually means if you're a business that's processing special categories of personal data. And it's very much for a specific purpose. Interestingly as well, we've got as one of the kind of lawful basis for processing special categories of personal data, and we should say all of the general categories, the lawful basis, the things we just talked about previously, those all have to be in place as well. The Article 9, Article 10, you've got to meet those requirements. And then when you're dealing with special categories of personal data, you've got to meet the additional requirements for processing special categories of personal data. And one of the requirements that's been included, and you can understand why it has, is there's specific rights for processing for employment purposes. And you know, if you look at the drafting in it, it's 11B, Article 11B of the law. I mean, it really talks about how you can basically process special categories of personal data as is necessary for processing in the context of a data subject's employment. Because knowing as businesses, like now Tamim is a business, we've got lots of employees in DIFC, we process a lot of employee data. You know, and you need to be able to do that for, and as the law says, for recruitment, visa or work permit processing, the performance of an employment contract, termination of employment, conduct of proceedings relating to employment. There's a long list in there, and there's a lot of detail around it, which is very useful. Also, there's the option as well in there for processing around from a health point of view, the assessment of the working capacity of an employee for medical diagnosis. And as we know at the moment, dealing with the pandemic, that's pretty important stuff. And there's a large number of categories. I'm not going to go through them all in terms of, bases by which you can process special categories of personal data. One at the end is an important one because it talks about processing that's necessary for substantial public interest, and that's a defined term under the new law, and it's a pretty broad definition, and there's a need, of course, it needs to be proportionate, and it needs to balance the data protection principles and suitable and specific measures to safeguard the rights of data subjects. But it's an interesting kind of catch-all that, particularly for kind of data controllers, data processors that are processing special categories of personal data, it's certainly one to look at. It's a requirement, to meet certain applicable laws. So we're going to move on from special categories of personal data, and we're going to look at consent. This is Article 12 of the new law, and consent it's interesting reading the guidance from the DIFC Data Protection Commissioner, because they've gone into a lot of detail on consent, and one of the things they've really flagged is that consent's is really not the only legal basis for lawful processing under the new law. And maybe previously consent was a bit of a default option. It wasn't particularly well defined under the law. It was open to interpretation. We defaulted back to consent. Now, consent remains a really important legal basis for processing, but the Data Protection Commissioner makes the point that you should be looking at other legal bases for processing as well. And one of the key changes in the new law is there's a lot of new detail, new obligations for data controllers, data processors in terms of securing consent from data subjects. And we've set this out in this slide, and as it demonstrates, consent needs to be given freely. It needs to be through a clear affirmative act, showing an unambiguous indication of consent. These are all new concepts. If a data controller, data processor wants to rely on consent as a basis for processing, and the controllers need to be able to demonstrate that consent has been freely given. So this really means that consent can't be conditional. It can't be linked to something. It can't be connected to, say, for example, negative consequences. So i.e., if you don't provide your consent to provide this personal data, then you won't get this benefit. And they use the example in the guidance of, if you provide this personal consent to process your personal data, we'll give you a better credit card rate. Now, consent, it's important to be clear, consent can come in a lot of different ways. Consent can come through signing, it can come through ticking the box, it can come through validating by an email link, confirming by email. It can even be oral, it can be by action. Now that's important to understand, is consent is not limited in the way that you can secure consent. But one of the key areas is that if you're going to rely on consent for processing, then you need to implement appropriate and proportionate measures to assess the ongoing validity of that consent. You've got to be able to put in place means to manage the recording of consent and also the recording of the withdrawal of consent. And you've got to be able to put in place a means of periodically evaluating the consent. And as you can see, that's a big administrative issue that's going to come in where previously really there wasn't that requirement. And data subjects must be able to reaffirm or withdraw consent on a periodic basis. And if data subjects are reaffirming consent, that reaffirmation needs to meet the law's requirements around consent. So it needs to be given freely. It needs to be clear and affirmative act. And the next bullet's an important one because really what it calls out is the fact that where you're processing personal data to cover multiple purposes, maybe marketing, maybe for processing for particular business requirements, you need to be calling those purposes out separately. Consent needs to be obtained, it needs to be clearly distinguishable for each purpose. It needs to be intelligible and easily accessible and use clear and plain language. And really the obligation is on the data controller to set out their consent in a way in which it meets the new law. And we work a lot with clients before the new law in terms of how to set out their consents in a way that meets the old law's requirements. And we've got you know, a lot more here that we need to work with in terms of how we structure the consents. And the key one at the bottom is data subjects may withdraw consent at any time. And one of the things that the DIFC Data Protection Commissioner flags in the guidance is because of this ability for data subjects to withdraw their consent, you may actually want to be looking at other legal bases for processing personal data, not necessarily be relying on consent, based on the fact that that data subject can withdraw that consent at any time, and that data subject needs to be informed that they can withdraw consent. They need to, and the ways in which they can do it at the time that consent is given, and also the process of withdrawal. I mean, gone are the days when consent was indefinite. Very much consent is needs to be reaffirmed, and if it's not reaffirmed within a reasonable time, it's actually deemed withdrawn. It just doesn't continue indefinitely. And the final point around consent, and this is a really important one, and the guidance flags this, and it's really important it does, and it's a concept that's been discussed a lot within GDPR, which is basically that consent is unlikely to be a good basis for employers to rely on in relation to employees, because there's that balance of power within the employer-employee relationship that makes consent a very difficult legal basis for processing for employers to rely on. And it's really open to challenge. So from an employer point of view, employers need to be looking for other legal bases for processing, and one of those could be legitimate interests. So let's look at legitimate interest, because legitimate interest has been a legal basis for processing personal data. It was there under the old law. It's there under the new law, but we've got more detail around really what legitimate interest covers for the purpose of processing. And really the two key ones are the fact that transfer of personal data by controllers within their organizational group for internal administrative purposes, and we've highlighted that, may be considered a legitimate interest. Now, equally, that really requires controllers to manage how if they're using legitimate interest as a legal basis for processing, they've really got to make sure it sticks within an internal administrative purpose box. It doesn't spread out and it isn't used for other purposes. Another one that's flagged under the new law is that a controller has a legitimate interest in processing personal data if it's necessary and proportionate to prevent fraud or ensure network and information security. So we're going to bounce on now to look at processing records, and really this comes under the heading of accountability, and there's a lot more accountability for both controllers and processors in the new DIFC law. And this is really where, for businesses that are subject to this law, this is really what you need to be thinking about in terms of the things that you're going to need to be putting in place. And one of the key things that controllers will need to maintain, and this is in Article 15 of the new law, is a written record, which may be in electronic form, that covers its processing activities. It's a record that needs to be kept up to date. It needs to contain, as a minimum, the information prescribed in the new law. And there's a lot of detail in the new law, very fortunately, sets out very clearly what that record needs to look like. But within that accountability requirement, and we flagged there accountability for controllers and processors, there's a need to establish a program to demonstrate compliance with the new law. Now, when we talk about accountability, the key things there is it all needs to be appropriate and proportionate. It all needs to be, all of these steps that need to be put in place, and they do need to be put in place, but the amount of effort and the work and the size of the program and the technical and organizational measures that are applied and the level of security really depends on the personal data that you're processing, and that's the analysis that businesses need to do, and very much look at what are we processing, what are the risks of that personal data, a personal data breach, and putting in place appropriate and proportionate measures in relation to that. And one of the concepts that's come into the new law is this principle of data protection by design and by default. It's a GDPR concept things around data minimization, processing only for specific purposes. But really keep in mind, all of these requirements very much need to be proportionate to what you do as a business. If you're processing a lot of special categories of personal data, a lot of financial information, the program you put in place, the measures, the security is going to be very different to if you're simply processing some employee data, kind of contact details, things like that, customer data. So we just flagged this one up as well, because one of the new parts of the law is there's this concept of default privacy settings, and we're not going to spend a lot of time on this, but really what it means is if controllers offering an online services for a platform, the new law really requires that the default privacy preferences only require the minimum personal data necessary to deliver or receive the services. So maybe gone are the days where to access online services through a platform that you had to give a lot of personal data up. Clearly that's not, the new law is looking at that and looking to put some controls in place. So one of the new concepts that have come into the new law is this concept of high risk processing activities. This is new. There's some guidance out, some new guidance out on it from the DIFC Data Protection Commission. It's very useful. It's also got a decision checklist in the guidance that allows you to work through. Because really the analysis that needs to be done is, are you conducting high risk processing activities? We'll talk about the definition. We've got the definition set up on the next slide. But it's important to look at, this is a real fundamental analysis that businesses need to do under the new law, because there's a lot of consequences if you do determine that you're undertaking high risk processing activities. Includes conducting data protection impact assessments, DPIAs, and also appointing data protection officers. So let's look at the definition. I want to spend a little bit of time on this, and this is very much focused on new technology coming in. And as the first point talks, definition of high risk processing activities includes processing that includes the adoption of new or different technologies or methods. It doesn't necessarily have to be a new technology like AI or blockchain, but it can be a new method that materially increases the risk to data subjects or renders it more difficult for data subjects to exercise their rights. So there's a real analysis that businesses need to do. This can also include processing of a considerable amount of personal data, where that processing is likely to result in a high risk to the data subject. So once again, this is an analysis of what kind of data are you processing? Is it sensitive personal data, financial tracking data? If it is, actually clearly there's a high risk to data subjects in that as a result of that processing. And actually, in those circumstances, you may not need to be processing a considerable amount to fall within the high risk processing activity to trigger a DPIA, the requirement for a DPO. And there's some really good examples in the guidance that the Commission has put out around what would be considered considerable amounts of personal data. And it talks about a company with a few hundred employees, a company that's dealing with a few thousand customer records. So it's giving some guidance on that. High risk processing activities also covers systematic and extensive automated processing, where there are significant legal effects to that processing, i.e. automated decision making, potentially profiling data subjects, and then also, as it says there, processing of special categories of personal data on a large scale. And once again, the guidance really helps analyze what large scale means. So we're going to talk about a DPO, because as we said at the start, this is a really important new concept. For those of you that are kind of new to the concept of a data protection officer, a DPO. I mean, a DPO is responsible for overseeing a company's data protection strategy and its implementation to ensure compliance with the data protection obligations of the company. That's what we said on the slide. And particularly under the new law, a DPO must be appointed both by certain DIFC bodies, but also by controllers or processors who are undertaking high-risk processing activities on a systematic and regular basis. So that's the importance of that analysis. Am I undertaking high-risk processing activities? If I am, it's going to trigger a requirement for a DPO. Interestingly, under the new law as well, there's a requirement from the commission that the commissioner may make a requirement for a controller or processor to appoint a DPO, whether or not that they're undertaking high-risk processing activities. And this may be in circumstances where a commissioner looks at certain activities that a controller or processor is doing and feels that the DPO is necessary really to put some controls in place. Interestingly as well, the new law talks to the fact that controllers or processors who do not need to appoint a DPO must clearly allocate responsibility within their organisation for oversight and compliance with the new law. So even if you don't have a DPO, you've got to have somebody within your organisation who's keeping track of what you're doing under the law, if you're subject to the law. And we just want to spend a little bit of time on what those DPO requirements are. Because, as I say, this could be an important new requirement for a lot of DIFC businesses, for a lot of businesses that are caught by the new DIFC law. Now, a DPO can be a controller or processor employee, or it can be contracted from a third party. And we're going to see a number of third parties coming in and offering DPO or virtual DPO services. A group can have a single DPO. A DPO would need to be a UAE resident unless a group DPO is in place and performing similar functions at an international level. And it will be important, particularly for international companies who fall within the new law, really to do the analysis and go, really, can my group DPO apply? Can I use the group DPO? Or based on the things I need to do under the new law, should I be appointing my own DPO? DPO contact details need to be published, readily accessible, and a DPO easily contactable. That's the transparency requirement. And DPOs can hold other roles in the controller or processor. And we put this one in because the likelihood is the DPO is going to be doing other work within a controller or processor. But it's important to recognise that a DPO has got a lot of responsibilities under the new law. There's a lot of detail in the new law talking about what a DPO needs to do. They need to have knowledge of the new law so that they can monitor and advise on compliance. They need to be able to act independently on their own authority, be objective, have direct access to senior management, have the resources in place to perform their duties as a DPO, have timely and unrestricted access to information within the controller or processor organisation. It's a long list there. They have to be able to interact transparently and cooperate with the commissioner. There's going to be a balancing act there in terms of the other role that a DPO may be playing within an organisation, whether that's somebody from the legal or compliance function or somebody else within the business. And one of the DPO requirements is going to be the requirement to perform an annual assessment of the controller or processor's compliance with the new law. And this is going to be an important piece of work. So really that choice of DPO, if a DPO is required, it's a really important one that businesses need to think through. So we're going to transition from there, and I'm going to transition now over to Krishna, who's going to pick up around on this next slide, which is the obligations on processors and sub-processors. So I'm going to hand it over to you, Krishna.
Thanks, Martin. Hi, everyone. Martin has just provided us an overview of the law and has touched upon some of the key definitions and conceptual changes brought about by the new law. I will run you through some of the rights and obligations stemming from the new law and fines for violations of these provisions under the new law. The new law provides compliance obligations on the processors as well as the controllers. So where a processor is being engaged by a controller, there needs to be a legally binding written agreement between the controller and the processor. The agreement should state out the nature of processing activities that are to be carried out, the types of personal data that will be processed, as well as it should set out the appropriate technical and organizational measures that the processor would be undertaking. It is to be noted that where a controller or a processor engage in processing activities without entering into a written agreement, it would be in breach of the law, which is subject to a penalty of 25,000 USD under this new law. Even where a processor wants to engage or appoint a sub-processor, this can only be done with a specific written authorization of the controller and as well as a legally binding agreement. From the processor, we'll move to the liability of joint controllers. So where there are, sorry. Just trying to pull up the slide. Yep, here we go. So where there are two or more people determining the purpose and means of processing personal data, they shall be called as joint controllers. And where there are two or more joint controllers, there would be a legally binding agreement between them, setting out the responsibilities and compliances of obligations under the new law. Now I'll cover the transfer of data outside the DIFC. As opposed to like the old law, the new law also divides the transfer of data from the DIFC into two parts, that is transfer to jurisdictions having adequate level of protection and transfers to jurisdictions that lack the adequate level of protection. The divergence from the old law is that the old law provided a definitive list of 42 plus jurisdictions which were considered as having adequate level of protection. However, under the new law, the commissioner will determine whether a particular jurisdiction meets the adequacy requirements based on a number of factors which are set out on the slide in front of you, which is the rule of law, for example, the general respect for individual rights and the ability for individuals to enforce their rights, the ability of public authorities to access personal data, the existence of an effective data protection law, and the international commitments and conventions that are provided in that particular jurisdiction. The commissioner's determinations will be available in regulations, and the law also sets out that at any given point of time, the commissioner may suspend the adequacy status of a jurisdiction and thereby rolling out amended regulations. Where the transfer is to a jurisdiction providing adequate level of protection, no further authorization or notification from the commissioner will be required. It is the transfers to jurisdictions that are lacking adequate level of protection that will require a different set of circumstances. Sorry, I'm sorry about the slides. Just moving on. Just a minute. Sorry about that. So moving on to the transfers to jurisdictions that are considered to be not providing adequate level of protection. There are three circumstances that have been rolled out under the new law where such transfers can be made, and these are A, where appropriate safeguards are in place, or where there are certain derogations provided under the law, or there are C, where there's limited circumstances under the law. Each of the conditions under each of these circumstances have been listed out in the slide in front of you. For example, under appropriate safeguards would include a legally binding instrument between the public authorities, or the use of standard data protection clauses as adopted by the commissioner, or approved code of conduct or certification mechanism, or binding corporate rules that will facilitate the transfer of personal data between members of a corporate group. With respect to derogations provided under the law, it would include data subjects' explicit consent after the data subject has been given proper information about the possible risks of the transfer due to the absence of the adequacy requirements of that particular jurisdiction, or where the transfer is necessary for performance of a contract, or for reasons of substantial public interest, or to protect the data subject's vital interest, or where it is necessary for compliance with applicable law, or subject to international financial standards to meet the anti-money laundering requirements. With respect to limited circumstances where data can be transferred outside the DIFC to a jurisdiction not meeting the adequacy requirements would involve where the transfer is not repetitive in nature, or it concerns only a limited number of subjects, or there is a compelling legitimate interest of the controller that in no way overrides the interests or rights of a data subject. I will move on to this new concept that is included in the new law, which is of data sharing. That is, for example, a controller or a processor may be approached by a public authority to disclose the data that they are processing. When this happens, the data controller should exercise reasonable caution and diligence to determine the validity and proportionality of the request and assess the impact of such disclosure on the data subject's rights as well. And where possible, it should also seek appropriate binding assurances from the public authority seeking such data. This was a new concept which was not added in the previous law, and this has been included in this law. Moving on, I'll talk about the most important part of this new law, which talks about updating the privacy notices. Unlike the previous law, where there was certain information that was to be provided to the data subjects, under the new law, there are additional requirements. For example, where the data controller is obtaining the information from the data subjects themselves, they should provide to the data subjects in a concise, transparent, intelligible, and easily accessible form the information such as the name of the controllers, the details of the DPO if there is, the purpose of processing, the lawful basis for processing the personal information, if there are any transfers that are going to be made outside the DIFC. Where the controller is not obtaining information from the data subjects, then it is the duty of the controller to provide such information to the data subjects within the time limits provided under the new law. Please bear in mind that this is a new addition because the time limits were not previously provided under the new law. And as per the time limits, the controller should provide this information to the data subjects within 1 month of obtaining their personal data, or where the processing involves communications with the data subjects, the information should be provided at the time the first communication is made. In case processing requires disclosures to third parties or processor, then at the time the first disclosure is made, such information should be detailed out to the data subjects. I'll move on to the data subjects' rights, which have expanded exponentially under the new law. The rights that we see on the slide were also existing under the old law. However, these rights have been expanded under the new law. For example, the right to access now comes with a limitation period. For example, that the controller has to respond to the data subject's request within 1 month of receiving the right to within 1 month of receiving the access request. For example, moving on to the right to erasure or blocking of personal data, the data subjects now has the right to withdraw its consent, and where the data subjects has withdrawn its consent, then the information needs to be erased, or where the lawful where the processing is no more considered necessary, or the processing is considered unlawful, or there's no other legitimate basis for processing that information. In such circumstances, the data subject has the right to request the controller to erase its information or block its information, and the data controller must comply with this. In terms of right of rectification, it should be noted that where a data controller is unable to rectify or erase the data subject's information, it should have provided this information to the data subject at the time of obtaining this information in order to prevent violation of the law. For example, if for any reason that it is unfeasible or it's technically not possible to rectify the data, so long as the controller has given this information to the data subjects at the time of collecting the information, the data controller would not be considered to be in breach of the law. Otherwise, it would be considered to be in breach. And you must note that under the new law, the maximum penalty is for breach of data subjects' rights. Similarly, the right to object also existed under the old law. However, under the new law, there are various circumstances under which the data subject can right to object. For example, where processing is carried out on the basis of the performance of a task, or where it is necessary for purposes of legitimate interest, or where the information is being disclosed to a third party, the data subjects has the right to object to such processing, or if it is in case of direct marketing purposes. So these were the rights that existed even under the old law. However, they've been expanded, like I mentioned, under this new law. And along with these rights, the new rights that have been added include the following. That is the right to withdraw consent. The right to withdraw is an absolute right, and it should be noted that where processing is relied upon consent, and in case the data subject withdraws its consent, such processing should be immediately stopped. However, do note that the right to withdrawal is prospective in nature and would not have a retrospective effect. Similarly, where the data subject feels that the data that is being processed is not accurate, it can always request the controller to restrict its processing for the time being. Likewise, where the data subject has requested the data controller to rectify, erase, or block a particular information, the data controller should ensure that it relays this information to all the third parties to whom it has disclosed the personal data. The right to portability is also a similar right that is found under the GDPR, which allows the data subjects to receive the information that it has provided to the data controllers. Similarly, the right to object to decision based on automated processing is also included now within the new rights, which includes that if an individual is being assessed basis its performance on some automated processing, or the individual's financial information is being provided, then the individual has a right to object to such processing and can request to evaluate his performance or provide this information basis any other means apart from automated processing. The right to non-discrimination is a new right which is actually found under the California Consumer Privacy Act and not the GDPR. The right to non-discrimination provides the data subject to exercise their rights and for the controller to not to discriminate against that data subject that is exercising its rights in terms of denying a particular set of goods or services, or compromising on the quality or the price of the goods and services that is being provided to the data subjects. So like I mentioned at the start of the data subjects rights, the data subjects are really enhanced under the new law, and these are the ones that have maximum penalties. This is profiling is again a part of automated processing. However, what is important to note here is that while the data subjects have a right to object to profiling, this will not exist if the data subject has explicitly given its consent to profiling, or where profiling is necessary for entering into performance of a contract between the data subject and the controller, or where profiling is authorized by a law that is applicable to the controller. So this gives us a snapshot of the new rights that are available under the law. Moving on to personal data breaches. Under the old law, any unauthorized intrusion was to be intimidated to the commissioner. However, under the new law, only where a data breach compromises the security, confidentiality, or privacy of a data subject should the commissioner be notified as soon as practicable in the circumstances. Similarly, if the data breach results in high risk of the confidentiality, security, or privacy of a data subject, then in such a case, the data subject should also be informed. If the risk of damage is immediate in case of a data subject, then the data subject should be notified promptly. The new law sets out the details of what all information needs to be provided, which was not present in the old law. Such details will include the type of breach that has taken place, the measures that the data controller will take in order to rectify the breach, the period within which the data breach would be rectified, so on and so forth. I'd like to call out here that under the obligations of the processor, one important obligation is that even the processor has the obligation to notify the controller in case the processing activities infringe the law. So not only the data controllers have this obligation, but so does the processor. So after having discussed all the rights and obligations under the law, I will move on to the fines regime under this new law. As you can see, the fines regime has increased drastically Under the old law, the maximum penalty amount was 25,000. However, under the new law, the maximum penalty amount is 100,000. And like I mentioned, the maximum amount is for breach of data subjects' rights. In addition to the administrative fines, the data subjects also have a right to claim compensation. And along with that, the commissioner also has the right to issue general fines, keeping in mind the seriousness of the contravention as well as the risk of the actual harm done to the relevant subjects. And like I mentioned, the fines will apply to both controllers as well as the processors. So this brings us to an end of the presentation where we've tried to recap the new law, and we'd be happy to take any questions going forward.
Right, thanks very much for that, Krishna. That was great. No, I really appreciate people's kind of staying with us while we walked you through. Say, there's a lot of detail there, and I think it was certainly important to dig into that detail, because really that's for businesses that are subject to the new law. These are the issues that they really need to get to terms with. And as we started with at the presentation, you really got that 3-month window to do it, 3.5 months to where we are now, 3 months from the 1st of July. So, you know, it's hopefully that's given you a reasonably detailed overview of some of the key aspects of the law, really the things that you need to be focusing on as you start your gap analysis. You look at, you know, those issues, you know, what do you have in place at the moment? Have you run GDPR compliance exercises? As you look at doing paper governance, kind of document due diligence, you know, what do our documents say? What do our customer-facing documents say? What do our employment documents say? What do our consents look like? Krishna talked to the privacy notices. You know, what needs to change there, particularly around the consent area. So what we're going to do is just going to thank you very much for those who have sent us some questions. There's some really good ones, and we're just going to pick up on a few of those now. We appreciate you're busy people and you need to get on, but if you can hang on the webinar, we'll certainly touch on a few of those. I'll take a few now, and then Krishna is going to take a few as well. One of the questions that's come up from a number of people is whether they can get a copy of the slides, and we can certainly make those available. Great first question though, literally came in right at the start of the webinar, which was asking the question as to whether there's any chance that the new law will be rolled out onshore in the UAE. Now, as we know, that there's a lot of talk, a lot of noise around a new onshore federal data protection law. You know, when that comes out, there's been a lot of talk about whether that will be coming out sometime in 2020. You know, there's been a number of initiatives around that coming out of various UAE government departments. You know, and I think really what we can say to that is, you know, certainly the expectation, like the new DIFC law, is we're going to see something that's pretty close to those GDPR principles, those key principles that we've just run you through. So we'll probably, you know, our expectation would be, and we won't of course know this until we really see the law come out, but you know, we would be expecting a federal law that probably looks a lot like the DIFC law. So thanks for that question. Just flicking through them. As I say, we've got a question as to the scope of the law. How does it impact an organization set up in mainland Dubai? And as we said at the start of the webinar, you know, the new laws clarified who may be subject to the law and who maybe won't. And particularly if you're a data controller, you're a processor, you sit outside the DIFC in mainland Dubai, but you're conducting processing activities in the DIFC, then there is a potential that the law you will be subject to the law, and you need to do that analysis. So just flicking through to another question. This is an employment question. Is data captured during the interview stage, should that be treated as personal data, even if we don't onboard the individual? And yeah, absolutely. And I mean, this is a key issue. Employment applications, you get a huge amount of personal data from CVs coming in from the interview process, from the interview notes, you know, and as a result of that, there's a lot of you're holding a lot of personal data, and that all needs to be managed in accordance with the new law. So I'm just flicking through. So there's a question that says, is consent necessary for processing employment data? Well, as we talked about in the webinar, I mean, actually the DIFC Data Protection Commission is really saying that really you can't rely on consent as a lawful basis for processing because of that employer-employee, that balance of power within that relationship. It's very tricky to rely on consent. It could be open to challenge. Doesn't mean you can't, but you have to understand that there's risks involved with that, and you've got to look perhaps to other legal bases for processing employee personal data. So another point of question down here is fund management. Is a fund management business considered a high risk processing activity? Well, it's an interesting question, and it really depends on what personal data is being processed as part of that fund management business, and that's the analysis that needs to be done. And we're working with our clients already in terms of looking at really what personal data they hold, what are they processing, what are they storing, where are they storing it, what are they transferring, where are they transferring it to. It's this analysis that you need to be doing now to really start working through to really identify, is it a high risk processing activity, and does that trigger DPIA, DPO requirements, for example. What do I have to put in place? What technical and organizational measures? What level of IT security? So there's a question here that says, regarding the annual assessment, and this is the thing that DPOs will need to take forward. And it says, regarding the annual assessment, does the new law set some requirements on what are the elements of this assessment? Well, they actually do, and it's very useful. Once again, I mean, the real benefit of the new law is there's a lot of detail, and I think we can expect more detail in regulations and more detail in guidance. But there is detail in terms of what that annual assessment would need as a minimum to cover. And that's really useful as a guide, certainly for DPOs coming into the role. And there's another DPO question here, and they ask, so can an entity decide not to appoint a DPO? Well, it's a good question. I think that analysis has to be done. And fundamentally, if you come to the conclusion that you are processing high risk, you're undertaking high risk processing activities, you've got to think very carefully about whether you really need a DPO, and the likelihood is that you're going to. Now, as we talked about during the webinar, that really does come with a lot of requirements to it, and you've got to understand what those requirements are. Also, as the new law enables, you're going to have some options around whether that DPO is somebody you employ internally or whether it's a service that you go out and contract for. So I'm just going to take a couple more. I appreciate we're a little bit past the top of the hour. But as I say, there's a few more really good questions, and I want to take a couple more, and then I'll hand over to Krishna to pick up on one or two. And there's one that says, so raising data for personal data connected while doing KYC, does the data subject wants to kind of withdraw from the process, what will happen to the status of the KYC data? Well, you need to, as I say, look at what the requirement is. So that all those data subject rights that Krishna talked to, those data protection principles around data minimization, you're going to need to be balancing those really with your KYC requirements. And as we talked about, there is, the businesses do have a requirement to comply with applicable laws, and this may well cover KYC and AML requirements. And that analysis needs to be done in terms of what data you actually need to maintain. And of course, that goes then to the transparency requirement around, you need to be making this clear to data subjects what data, personal data you're retaining, why you're doing it, how long you're retaining it for. Just a last question from me. This is a great one. So some of the data can be kept anonymized even after the consent for erasure. So this is where a data subject withdraws their consent. And one of the areas we didn't touch on in a lot of detail is cessation of processing. So this is where the basis for processing changes, ceases to exist, or a controller is required to cease processing due to the exercise of a data subject's rights. And that, for example, could be a data subject withdrawing their consent. So in those circumstances, the new law really does set out a lot of, various different options that a controller will have, whether they securely or permanently delete the data, whether they anonymize it, synonymize it, whether it's securely encrypted, or they talk to the concept to put it beyond further use. And as I say, we didn't go into this in a lot of detail, but it's an important point that businesses will need to understand in terms of what their options are in relation to what they do with the data once processing ceases. So I'm going to stop there. Krishna, I'm just going to, if you could pick up on a couple of the questions, that would be great.
Sure. I can see a question on asking about the retention period. So under the new law, like the old law, it says that the data should not be retained for longer than is necessary. So that is the retention period. So the companies would have to assess as to how long do they actually require the data, and beyond that, it should technically be deleted. In terms of where it's another question I read that anti-money laundering law requires processing personal data. So whether this requires consent. So I would respond to this by saying that wherever personal data is being collected, you would need the consent of the individual to whom the personal data belongs. Because somewhere in the other questions also I read that whether employee consent would be required. So the law does not distinguish between various kinds of data, like for example employee data or data relating to anti-money laundering activities, but it just says generally wherever personal data is being collected, the provisions of the data protection law are to be followed. I see a question on how far do we see the non-discriminating clause extending. Well, this is, like I said, this is a completely new right that is being provided. If we go strictly by the terms of the law, it says that it'll extend to basically to any controller discriminating against any data subject who's exercising its rights, and in terms of providing or denying them the goods or services. That would be my answer, but in practicality we'll have to see to how far it actually materializes. This is an interesting question which says, is the new data protection law applicable if we use DIFC law as the law of contract? So going back to the slide where Martin said that the applicability of the law will only be to data controllers or processors who are set up in the DIFC, or who are incorporated irrespective of where they are processing the information, or those controllers and processors who are either processing by means or their personnel being set up within the DIFC would be covered within the ambit of this regulation, and not anybody who uses DIFC law as the governing law of their contract. That would be my understanding.
That's great, Krishna. Thanks very much for those. I think we'll call it. We've just got lots of questions. I really appreciate those. Look, we'll aim to follow up with people offline on those. Really appreciate you kind of sending us your questions. And clearly, from what really one of the things we see from the questions is, there's a lot of work people are already doing, a lot of thinking people are already doing in terms of their compliance with the new law, whether they are the type of office, whether they're a representative office or a branch, the amount of personal data that they process, the things they process it for, whether it's KYC, AML, whether it's just employee data or it's employee and customer data, and then the types of data as well. So anyway, we'll leave it there. Many thanks for joining the webinar. The slides you see at the moment, that's what we look like, and our contact details are at the bottom with our emails, albeit I've just noticed my email is spelled incorrectly. So, really do feel free to get in touch. We're already engaging with our clients really to start working with them in terms of preparing for the new law, for the coming into force in the 1st of July and implementation by the 1st of October. So do please let us know if we can assist. So thanks so much for attending, and have a great day. Thanks so much.
Thanks, everybody.